Rise. The Washtenaw County Trial Court is now in session. The Honorable Darlene O'Brien presiding.
Good afternoon. Please be seated.
People versus Devontae Gambles, 22495 FH.
Good afternoon, Your Honor. Michael Doby for the people.
Good afternoon. And do we have the public defender?
Overwater Assistant Public Defender, Your Honor. It's my understanding Mr. Gambles has private counsel.
Okay. Mr. Gambles, please raise your right hand to be sworn.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Can you state your name for the record, please?
Devontae Gambles.
Thank you.
Good afternoon, Mr. Gambles. You're before the court on a community corrections petition for a bench warrant to find you in contempt for violating the conditions of your bond. It's alleged that you left home confinement. You're entitled to a contested evidentiary hearing. So it does appear that you have an attorney, Mohammed Nasser. And Mr. Nasser, has he checked in? He has not checked in.
Or Edward Martell.
He has not either.
He hasn't checked in. So do you want me to see if the public defender would represent you just for purposes of today's hearing? Or do you want this adjourned so your attorney could be present?
I have it, because if I have it adjourned, then I would have to sit and wait, right?
I'm sorry, I didn't quite catch all of that.
I said, if I have it adjourned, I would have to sit and wait, right? Would I be able to do a breakout room with the public defender so they know what's going on? My tether agent, everybody.
No, do I have another case?
Yeah, we can do one for like 2 or 3 minutes.
Okay, we can do one for a couple of minutes. Mr. Overwater, are you available?
Yes, Your Honor.
Okay, and would you be willing to meet with Mr. Gambles?
I'd be happy to.
Okay, thank you. So we'll put you in a breakout room and then you can decide how you wish to proceed.
Thank you.
One moment. Seven, People versus Tyler Bradford, 23328 FH.
Michael Doby for the people.
Good afternoon, Your Honor. Raymond Burkett on behalf of Tyler Bradford. Tyler, would you identify yourself to the court, please?
Tyler Bradford.
Good afternoon. So, Mr. Burkett, today is the time and date set for the pretrial. How do you wish to proceed?
Your Honor, after thorough discussions with Mr. Doby, I think we have got the matter resolved. If this honorable court would allow us to place it on the record, listen to it. Can I go
now
forward?
Before you do that, I don't know if you're aware that this docket is being transferred to Judge Ariane Slay. So if you put in a plea today, Mr. Bradford, you would have to sign a sentencing judge waiver. And I don't know if you've had the opportunity to discuss that with your client, Mr. Burkett?
I have not, but the prosecutor has made an offer to us. I would like to put that offer on the record. I'd like for this court to accept the offer, and we'll go from there.
So what is the offer, counsel?
Your Honor, the offer is to plead guilty to count 2 and an added count 3, which would be fleeing and eluding third degree under the penal code. The defendant is HIDA eligible. There would be an agreement to HIDA sentencing. His guidelines, if convicted as charged, would be 0 to 17.
Okay, so I'm looking at 3 counts already. So
I'm sorry. You
so
are right. It
is
would be
it-
an added 4.
okay, so would he be pleading to count 2 or 3?
You would plead to count 2 and
2.
4.
And 4, got it. And 4 is going to be?
Fleeing and eluding third degree under the penal code, 750.479A3.
Which is a felony punishable by,
5 years or $5,000.
thank you. And is there any sentence agreement?
The sentencing under the Home Youthful Trainee Act.
Okay. Is that all correct, Mr. Burkett?
That is correct, Your Honor. And I should tell you, but I explain it to my client and he understands it.
Okay, and do you want to see if he is interested in pleading today, if he signs a sentencing judge waiver, or if he'd like to adjourn so he can put in the plea before Judge Slay?
So we have no problems with, no problem putting it in before you, and we'll post that on the record. Can I more do here on that one issue?
Sure.
Mr. Tao, Mr. Bradford, can you hear me?
Yes,
Okay. Do you understand what this honorable court is saying? That we're going to enter a plea today. We can. And you already know the terms of the agreement that you're going to get a home useful training. But this honorable court won't be the one that will sentence you. It will be another judge. But we already have the agreement in place. Okay? You understand that?
yes,
And do you agree to that, sir?
yes.
Okay. Yes, Your Honor. I have no further questions.
Okay, thank you. So, Mr. Bradford, you'll need to unmute your device again and raise your right hand to be sworn.
Okay.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
Can you state your name again for the record, please?
Tyler Bradford.
Thank you.
Mr. Bradford, did you hear and understand all of the statements that the attorneys and I just made?
Yes,
And do you want to enter those 2 pleas in accordance with the agreements of the attorneys?
yes,
Have you had sufficient time to consult with your attorney about what to do here today?
yes,
I need to advise you, sir, that count 2, assaulting, resisting, or obstructing a police officer is a felony punishable by up to 2 years and or $2,000, and there could be a consecutive sentence if the assault was committed in a place of confinement or for another violation arising from the same transaction. An added count 4, fleeing and eluding third degree under the penal code is a felony punishable by up to 5 years and or $5,000. Understood?
yes,
There are a number of rights that you'd be giving up if you enter these 2 pleas. You have a right to a trial by a jury or by the court if all parties agree. You have the right to be presumed innocent and to have the prosecutor prove you guilty beyond a reasonable doubt. You have the right to have witnesses against you appear at a trial and to see, hear, and question those witnesses. You have the right to call witnesses to testify. You can ask that the court order that witnesses appear for your trial. You have the right to remain silent and not have your silence used against you. you, and you also have the right to testify if you so desire. But if you enter this plea today, you would give up all of those rights. There would not be a trial, and the prosecutor wouldn't need to prove any of these allegations. Do you understand all of that?
Yes.
And do you still want to go ahead with these two pleas today?
Yes.
So at the time of these offenses, were you on probation or parole?
No.
Are there any potential immigration consequences, counsel?
None that I'm aware of.
Not
Mr.
that I'm
Doe-
aware of.
Okay. And are you entering these pleas of your own free will?
Yes.
Has anyone threatened or coerced you in any way to get you to enter these two pleas?
No.
Has anybody made any promises or inducements other than what was stated here on the record today?
No.
Are counsel aware of any threats or promises not on the record?
No, Your Honor.
No, yeah.
So do you understand, Mr. Bradford, that by entering the pleas, you would be giving up your right to be able to argue to an appellate court, either that pleading was not of your own free will, or you couldn't argue that there were some threats or promises that we didn't talk about today?
Yes.
And you'd be giving up your right to a direct appeal, which means if you wanted to appeal from either your conviction or your sentence, you would have to ask permission of the appellate court. And we have no way of knowing what they would say to that.
Yes.
And finally, you would be waiving your right to appeal any issues that might have been available to you at the end of a trial, because there won't be a trial in your case. Understood?
Yes. Yes.
And knowing all of the things that we've talked about this afternoon, do you still want to enter these two pleas today?
Yes.
So turning your attention to April 4th, 2022 in Ypsilanti Township, Washtenaw County, at or near 1115 Nash Avenue. To count two, assaulting, resisting, or obstructing a police officer, how do you plead?
Guilty.
And to added count 4, fleeing and eluding third degree under the penal code, how do you plead?
Guilty.
Tell us what you did that makes you guilty of those offenses. And Mr. Burkett, feel free to inquire if you'd like.
Certainly. Mr. Bradford, time and day, is it true that you ran from the police officers knowing that they were legally trying to stop you?
Yes.
Okay. And, and they had their lights and sirens and things going at that time. You knew that, didn't you?
Yes.
And you chose not to stop. Is that correct, sir?
Yes.
Okay. Your Honor, I think that would cover it.
Mr. Doby?
I'm satisfied as to the fleeing. And as to count 2.
Yes. Yes. I'm sorry, I didn't hear you, Mr. Dovey.
I'm satisfied that establishes the facts for the fleeing and eluding. But as to count 2, the resisting and obstructing.
Okay. Sir, is it true that you refused to cooperate with the police? You obstructed them from doing their investigation in this case. Is that correct, sir?
Yes.
And you understood what you was doing was in violation of the law. Is that true, sir?
Yes.
Okay. I have nothing further, Your Honor.
I'm satisfied.
And counsel, do you believe I've complied with the court rules?
Yes, Your
You
Honor.
have. Yes, Your Honor.
I accept your pleas. I find them to be knowingly, voluntarily, understandably, and accurately made. I can set your sentencing before Judge Slay for Monday, September 11th at 1:30. Would that be a good date for you, counsel?
I'm checking real quickly. Yes, Your Honor.
Okay, so you need to call probation, and you should do that this afternoon to make your appointment for your pre-sentence interview. You need to make sure you keep your appointment so they'll be ready for you on September 11th for your sentencing. The court does expect all monetary obligations to be paid at the time of sentencing, and all bond conditions continue to apply in the meantime. So, Mr. Burkett, do you wish to be present for that pre-sentence interview?
I do not.
Okay. I think that's covers everything for today. Anything further, counsel?
No, thank you.
On behalf of the defense, we have nothing.
Okay, thank you.
Thank you, Your Honor.
You're welcome.
Recalling People versus Devontae Gambles, 22495 FH.
Michael Doby for the people.
Jonathan Overwater, Assistant Public Defender, on behalf of Mr. Gambles for purposes of today's arraignment only.
And Mr. Gambles, do you want me to appoint the public defender for purposes of today's arraignment only?
Yes, ma'am. I think we went over.
Okay, I will do that. I believe I've already read the allegations. So, Mr. Overwater, how do you wish to proceed?
Yeah, I'm going to be asked to set this matter for a hearing before Judge Kunke, and I'd ask to address the issue of bond.
And the next available date for Judge Kunke?
Our next date is going to be August 1st at 1:30, but it is pretty full.
August 1st at 1:30. It's pretty full.
It's very full. We could go to August 8th.
Okay, well, why don't we talk about bond first, and then you can choose your date. So as to bond, Mr. Overwater.
Yeah, I'm going to be asking that the court reinstate Mr. Gamble's bond and tether him to a different location. The location he was at in Inkster, he was living with another person. He indicated to me that person was abusing alcohol and would become belligerent, and he had to get out of that location. He has stayed in contact with Agent Casey, who was his tether agent at Community Corrections. Mr. Gambles was actually able to provide me with a number of different phone numbers for Community Corrections as well as his attorneys. I tried all of those numbers, unfortunately, and nobody answered any of the calls. But he does indicate that he has been in contact with Agent Casey. The Agent Casey is the one who advised him to turn himself in. He's actually made 3 different attempts to turn himself in. But on the first 2 occasions, the warrant wasn't even active yet. So he couldn't be taken into custody. Finally, it was active yesterday, and he was taken into custody. He'll be staying with his mother in Taylor. I was able to speak with her and confirm that he can stay there. I have the address I can provide. So it seems like there was an issue. He was doing his best to resolve that issue and stay out of trouble. And it seems like if his counsel had been here or had filed the appropriate orders, stipulated orders to amend his bond conditions, this would have been resolved much more easily than it has been.
They told me they did.
Oh, just a moment. Mr. Doby, your position?
Thank you, Your Honor. I'm asking that this defendant be remanded. Of course, it doesn't say explicitly in the warrant what he was arraigned for, but my understanding it was for domestic violence, and that there have been ongoing domestic violence cases at that home in Inkster with the defendant as the defendant or perpetrator.
So what about if, I'm sorry, I didn't know if you were done.
I just had to clear my throat. I'm sorry. With the in addition to the tether violations, there being new criminal activity, violent criminal activity, I'd ask that he be remanded.
Well, I wonder if we could do a tether with a no-go to that Inkster location, if he can stay with his mother until this can be decided by Judge Kunke.
Yes, ma'am.
Would he be amenable to that, Mr. Overwater?
Yes, ma'am. Yes, Your Honor. That's exactly what I would ask for.
Okay, and that's what I will do, assuming that what he says is accurate, that it was the individual in the home that was the problem and that's why he left. What I will do is allow him to be released on a personal $500 personal recognizance bond. So if you do not appear for your hearing in person before Judge Conkey, then you would owe the court that $500. And you're going to need to report to probation. Hopefully, they will have tethers so they can put the tether on tomorrow morning.
Still have
Agent
it.
Pollard, does that sound agreeable?
I still have it.
Judge, I believe he's on tether, which is.
He's got a tether? Okay.
I brought my charger with me. I'm fully charged up. Everything is ready to go. I turned myself in 3 times to handle it.
Okay.
Mr. Gamble. Okay.
So then it's going to be the tether location that he can't go to is that residence in Inkster, in addition to any other locations that were on there. Okay? And now that you know how we're proceeding regarding bond, what date would you like, Mr. Overwater?
He actually is already on the docket for August 1st
Yes.
for a pretrial.
Yes.
Okay.
So without his attorney being here, I wouldn't reschedule it.
Okay, that's fine. We'll just keep it as is then on August 1st at 1:30. And remember, that's in person, Mr. Gambles.
Yes, ma'am.
Judge,
Okay,
Does the
Judge,
court-
Yes.
Could we get his address on the record?
He's going to be staying at 12435 Pine Street. And that's in Taylor, Michigan, 48180.
Was that 12435 Pine?
Yes, sir.
Thank you.
And Judge, does the court need another community corrections order or is the dispo sufficient?
well, the dispo is sufficient to get him out of jail, but it may not be sufficient to get that other address added. So we may want to do a new order.
I can do a new order, but did Mr. Dobie have the address? I don't have the Inkster address.
Can I tell you, or
I don't have it handy.
Yes, Mr. Gambles, if you would.
the address was 26345 Hopkins, Hopkins, Inkster, Michigan, and
That's all I need. I can do the rest.
All right, thank you. Good luck to you, Mr. Gambles.
Thank you.
Thank you, Judge.
Right, go on out, I'll put you back to one, okay? Go back to where you were in.
Numbers 19, 20, and 21, People versus Augustin Hernandez, 22434 FH, 2308 FH, and 23324 FH.
Michael Dobie for the people.
Edward Drucas for Augustin Hernandez.
Good afternoon. And do we have Mr. Hernandez?
We do, Your Honor, if you could state your name.
Ah, okay.
Good afternoon. This is Gloria Reinhold. I'm the Spanish interpreter for Mr. Hernandez.
Please raise your right hand to be sworn.
Do you swear or affirm that you will interpret and translate the English language into Spanish and the Spanish language into English between the court, counsel, and the witness to the best of your ability?
I do.
Could you please state your name again for the record?
Gloria Reinhold. Good afternoon.
Thank you.
You're welcome.
Ms. Reinhold, have you been able to communicate with Mr. Hernandez to see if you two understand one another?
Well, I have interpreted for him in the past. I believe we
Okay.
haven't had any problems, but yeah, thank you.
Great. Okay. So today is the time and date set for sentencing, and we are proceeding today by Zoom.
Sí, el día de hoy, la fecha y hora para la sentencia, estamos procediendo vía Zoom.
Mr. Hernandez, you have a constitutional right to an in-person sentencing if you so desire.
Mire, señor Hernández, usted tiene el derecho constitucional de tener una sentencia presencial en persona, si usted así lo desea.
I assume that you've discussed that right with your attorney.
Yo asumo que eso usted lo conversó con su abogado.
Are you waiving that right to proceed this afternoon by Zoom?
Usted está renunciando a su derecho que usted tiene de proceder hoy en la tarde a través de Zoom.
Sí.
Yes.
And counsel, do either of you object to proceeding in this manner?
Y si alguno de los dos abogados tiene alguna objeción de proceder de esa manera, no, su señoría.
No, Your Honor.
No, su señoría.
No, Your Honor.
And thank you. So, Mr. Drukas, have you reviewed the pre-sentence report with your client?
Licenciado Drukis, ¿usted revisó el reporte previo a la sentencia con su cliente?
Yes, Your Honor, we've reviewed the report. We have no additions or corrections.
Así es, su señoría. Revisamos el reporte. No tenemos ninguna adición ni ninguna corrección.
Mr. Dobie, I'm sorry, Mr. Drukas?
And I guess I can address the guidelines at the appropriate time.
Y yo puedo hablar sobre lo de las pautas o directrices en el momento apropiado.
Mr. Dobie, do you have any additions, corrections, or deletions?
I have none, Your Honor, assuming that the court and Mr. Drukas received the victim impact statement that was emailed yesterday.
¿Usted tiene que hacer alguna adición, corrección o eliminación al licenciado Dobie? Yo no tengo ninguno. Nada más quiero asegurarme que el licenciado Drukis recibió en el día de ayer el reporte de impacto en la víctima.
I have reviewed and received and reviewed that victim impact statement. Mr. Drukas?
Y yo recibí y leí la declaración del impacto de la víctima, licenciado Drukis.
Yes, Your Honor, we have received it and reviewed it.
Sí, señoría, lo recibimos y lo revisamos.
Mr. Dobie, as to the sentencing guidelines then?
Thank you, Your Honor.
Licenciado Dobie, entonces en cuanto a las pautas y directrices de la sentencia, ¿sí, su señoría?
I have no challenges to the sentencing guidelines.
Sí. No tengo ningún desafío en cuanto a las pautas para la sentencia.
And the defense has no objection to how the guidelines were prepared. We believe that they are fair and accurate.
Entonces, la defensa no tiene ninguna objeción en cuanto a las pautas. Estamos preparados, pensamos que son justas.
So then the minimum sentencing guideline range in case number 22434FH.
Entonces, el mínimo, la sentencia mínima en cuanto a las pautas o directrices dentro de un rango para el caso 22434FH
would be 2 to 17 months.
Sería de 2 a 17 meses.
And on case number 2308FH, 0 to 17 months.
Y en el caso 2308FH sería de 02 a 17 meses.
Agreed, Your Honor.
¿Estamos de acuerdo, su señoría?
Agreed, Your Honor.
De acuerdo, su señoría.
Anything further, Mr. Dobie?
¿Algo
No,
más,
thank you, Your
licenciado
Honor.
Dobie? No, gracias, su señoría.
So no oral victim impact statements this afternoon.
That's correct, Your Honor.
En la tarde de hoy no va a haber ninguna declaración del impacto de la víctima oral o verbal. Así es, su señoría.
Mr. Drukas.
Ahora, licenciado Drukis.
Your Honor, I've been working with Mr. Hernandez. I believe that he is remorseful and ready to put this behind him. I know he wants to give a brief statement based on what was in the report, and I think that he will be. I'd like the court to follow what was recommended, and that was probation in this case. He has served quite a bit of time with these cases, and that's reflected in that report.
Mire, su señoría, el señor Hernández ha mostrado bastante remordimiento. Él quiere dejar en esto en el pasado. Él quiere dar una declaración breve, según lo que él leyó en la declaración, en el reporte. Él quiere queremos que se sigan las recomendaciones que ha sugerido la probatoria. Él ya ha cumplido una pena o bastante tiempo.
And I would just ask for the court to, with what they can, waive any type of fee in this case. He did spend some time in custody, 300 plus days. As far as it does have me that I'm appointed in this case, he was not able to hire a counsel. It did award attorney fees. I'd ask the court to potentially waive the attorney fees in this case.
Entonces yo le pido a la corte que de ser posible no le cobre ningún cargo a él. Él tuvo que pasar un tiempo en la cárcel, ya pasó en la cárcel más de 300 días. Él no se pudo contratar a un abogado privado. Y yo le pido que en la medida de lo posible le obvie o no le cobre a los cargos por abogado.
And since his release, he has gained employment and been productive, and I don't expect him not to continue that. So with that, we're asking the court to follow the recommendation, and I know he wants to give a statement.
Entonces, él después que lo dejaron salir, él haya tenido empleo, él ha sido productivo, y yo le pido a la corte que siga las recomendaciones, y él quiere dar una breve declaración.
Your Honor,
And yes, Mr. Doby.
I apologize for interrupting, but I did have one addition that I neglected. In case 22-324 FH,
Su señoría, le pido disculpa porque hubo, por negligencia mía, no dije algo, omití algo. En el caso 22324 FH,
there is a restitution request of $1,000 for the deductible for the broken window.
entonces,
Or
se está
windshield.
pidiendo que indemnice o pague el monto de $1,000. Eso es el deducible por haber roto el parabrisas del carro.
And that was in case 22324 FH, correct?
Sí,
Yes, Your Honor.
Eso fue en el caso 22324 FH. Así es, su señoría.
And then in terms of case number 224334 FH, the assault with a dangerous weapon case. In that case, would Mirabella Gomez be the victim he should not have contact with instead of Jorge Patino, who is the victim on case number 2308 FH?
You are correct, Your Honor. Thank you.
Entonces, en el caso 22434 FH, el cargo de agresión con un arma peligrosa, la señora Gómez es la señora con la que él no puede tener contacto. Entonces, Jorge Patiño es la otra víctima en el caso 23-08. Así es, su señoría.
Okay, thank you. So now, Mr. Hernandez, is there anything you'd like to tell me before I impose sentence?
Señor Hernández, ¿hay algo que usted me quiera decir a mí antes de yo imponer la sentencia?
Yes, ma'am. I'm sorry to the court. I'm sorry to the other people involved in my cases. And moving forward to obeying me. Thank you so much.
You're welcome.
De nada.
So it does appear, after my review of the pre-sentence report, that alcohol played a significant factor in some of these offenses.
Mire, aparentemente, después de yo haber revisado el reporte previo a la sentencia, que el alcohol jugó un factor significativo en todo esto.
And council, we need to set a goal for Mr. Hernandez probation. I was going to suggest maintaining sobriety.
Entonces, mire, licenciado, debemos fijar una meta o objetivo para la probatoria del señor Hernández y yo sugiero que sea sobriedad.
I agree, Your Honor.
Y yo estoy de acuerdo, su señoría.
And Mr. Drucas?
We would agree with that statement, Your Honor.
Y usted, licenciado, creo que estamos de acuerdo también con eso.
So in case number 22434FH.
Sí. En el caso
And-
22434FH.
And also in case number 2308FH.
Sí. Y también el caso 2308FH.
In each of those cases, I am sentencing you to 24 months probation.
En cada uno de esos casos, por los dos, lo estoy sentenciando a 24 meses de probatoria.
Subject to a number of conditions that I'll just briefly summarize.
Entonces, sujeto a varias condiciones que le voy a resumir brevemente.
You must not use or possess alcoholic beverages or non-prescribed controlled substances.
Sí, usted no debe usar ni poseer ningún alcohol, ni tampoco ninguna sustancia controlada que no sea recetada.
And you must comply with any testing, treatment, and any assessments of any sort when you're directed to those.
Y cuando usted así se lo instruyan o se lo digan, usted tiene que someterse a pruebas, a tratamientos y cualquier evaluación que le digan que usted tiene que hacer.
You must complete the Alternative to Domestic Aggression Program.
Sí, usted tiene que completar el programa de agresión doméstica, la alternativa.
And waive confidentiality regarding any program that you're required to attend.
Y obviar la confidencialidad de cualquier programa que usted deba asistir.
You must obey all court orders and not engage in any assaultive, threatening, or abusive behavior.
Sí, usted tiene que obedecer todas las órdenes de la corte y usted no puede cometer ningún comportamiento que sea agresivo, amenazante o abusivo.
You must not engage, you must not associate with anyone you know to have a felony record.
Sí, usted no se debe asociar con nadie que usted sepa que tenga un récord de felonías o delitos graves.
You must not change your residence without getting written permission in advance from your agent.
Sí, usted no puede cambiar de residencia a menos que a su agente le dé con antelación un permiso por escrito para así hacerlo.
You must contact your supervising probation agent no later than the first business day following your placement on probation or any release from jail.
Entonces, el primer día después que usted lo hayan dejado salir o el primer día que usted empiece su probatoria, usted debe ponerse en contacto con su agente probatoria supervisor.
And you must comply with any verbal or written orders of your agent.
Y usted debe cumplir con cualquier orden por escrita o verbal que le dé su agente.
You must submit to a search of your person and property, including but not limited to your vehicle, residence, and computer.
Entonces, usted debe permitir que cateen o registren tanto su persona como su propiedad, su residencia o su computadora.
Without the need of a warrant if the agent has reasonable cause to believe that you have items that would violate the conditions of your probation.
Y eso es sin obtener ninguna orden de la corte en caso de que su agente sospeche que usted pueda haber violado alguna de sus condiciones de probatoria.
You must report any arrest or police contact, loss of employment, or change of residence.
Entonces, cualquier arresto que usted tenga, cualquier contacto con la policía que usted tenga, si usted pierde su trabajo, si usted cambia de residencia, usted lo tiene que reportar de inmediato.
Your agent within 24 hours, weekends and holidays accepted.
Entonces, usted lo tiene que reportarse a su agente probatorio en un plazo de 24 horas, y esto incluyendo fines de semana y feriados.
On the 434 case, you must not have verbal, written, electronic, or physical contact with Mirabella Gomez, either through another person or directly, and you must not be within 500 feet of her residence, school, or place of employment.
Entonces, en cuanto al caso 434, usted no puede tener ningún contacto ni verbal, ni electrónico, ni físico, ni a través de un tercero tampoco, con Mirabel o Maribel Gómez. Y usted se tiene que, no puede tampoco pedirle a ningún tercero que lo haga por usted. Y usted se tiene que mantener alejado a 500 pies de distancia, ya sea de la casa de ella, el trabajo de ella, o employment, residencia, o si ella estudia en la escuela o universidad.
Now, I think I misstated that. That is the one with Jorge Patino.
Creo que me equivoqué. Eso es en el caso de Jorge Patiño.
So you must, those restrictions apply to Jorge Patino in that case. And
esas restricciones aplican al caso del señor Jorge Patino, en ese caso.
On the 08 case, you must not have contact with Mirabella Gomez, either directly or through another person.
Entonces, en el 08, y usted no puede tener ningún contacto con Maribel o Mirabel, ni directamente ni a través de ningún tercero.
And in each of these, well, in the first case, you must pay the $60 DNA fee.
Entonces, en el primer caso, usted tiene que pagar a $60. Eso es por el cargo del ADN.
And then in each of the felony cases, you must pay a $68 state costs.
Entonces, en cada uno de los casos de los delitos graves, usted tiene que pagar $68. Eso es al costo al Estado.
And crime victim assessment of $130.
Y $140, esa fue la evaluación a la víctima del delito.
And you must not use or possess any weapons or ammunition.
Y usted no debe ni usar ni poseer ni armas ni municiones.
And then turning to case number 22324FH.
Entonces, en cuanto al caso 22-434FH,
you must pay restitution in the amount of $1,000 to Mirabella Gomez.
Sí. Usted tiene que pagarle una indemnización o reponerle a la señora Maribel Gómez un monto de $1,000.
You make the payment into the court and the court will disperse to her.
Sí. Usted hace el pago a la corte y la corte le desembolsa ese dinero a ella.
You are not to have any contact with Mirabella Gomez.
Sí. Usted no puede tener ningún contacto con Maribel Gómez.
Directly or indirectly.
Ni directamente ni indirectamente.
And you must pay the $50 state costs.
Sí. Y usted tiene que pagar los $60 que es un costo al Estado.
And crime victim assessment of $75.
Y $75 que es una evaluación a la víctima del delito.
In each of these cases, you're entitled to file an application for leave to appeal from your conviction and sentence.
En cada uno de estos casos, usted tiene derecho a presentar una apelación por la sentencia de este caso.
If you can't afford an attorney, one can be appointed for purposes of appeal.
Entonces, si usted no puede contratarse a un abogado, le pueden designar a un abogado para fines de apelación.
However, the request for appointment of appellate counsel must be filed within 42 days of today's sentencing.
And this is interpreter, Your Honor. Did you say 42 days, right?
Correct.
Thank you. Usted tiene, si usted quiere pedir que le designen un abogado para fines de la apelación, Usted tiene 42 días a partir del día de hoy para hacerlo.
So, Mr. Drukas, you'll need to give 4 forms for his appellate rights to your client.
Entonces, mire, usted le tiene que dar al licenciado Drukis el formulario donde dice cuáles son los derechos de apelación a su cliente.
Yes, Your
Good
Honor,
luck.
I will provide those before he leaves my office.
Sí, antes de que
Thank
se
you.
vaya de mi oficina, yo se lo voy a dar. Gracias.
Good luck to you, Mr. Hernandez.
Buena suerte, señor Hernández.
Thank you.
Your Honor.
Gracias, señoría. Thank you. So I guess I maybe excuse.
And thank you for interpreting.
Oh, you're welcome. Bye-bye. Thank you. Bye.
Bye.
Supplemental number 7, People versus Jonathan Franklin, 21425 FH.
Michael Doby for the people.
And Mr. Franklin, can you hear me?
Yes. Yes. Yes.
Okay. Please raise your right hand to be sworn.
Is this an arraignment or I'm sorry, what is this?
Yes, this is an arraignment.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Confused. Is this an arraignment for a probation violation or arraignment?
Yes, sir.
Oh,
Do you swear to tell the truth, the whole truth, and nothing but the truth, sir?
yes.
Okay, you're before the court on allegations that you violated your probation. The maximum potential penalty is 4 years. You're entitled to a contested evidentiary hearing. Can you afford to hire your own attorney this afternoon?
No, I can't. No.
I'll appoint the public defender to represent you. Mr. Overwater?
Your Honor, I apologize. I didn't know that Mr. Franklin was added to today's docket, so I did not see him at the jail this morning. So I'm just trying to pull up information right now.
And he is at the jail. Okay.
I could give him 2 minutes. I gave him a couple. To correct the journey.
So we can go in a breakout room. Would you like to go into a breakout room with Mr. Franklin, Mr. Overwater?
Yes, please, Your Honor.
Okay, we'll pass this matter. Let us know when you're ready.
I'll put one thing for Mr. Overwater's information. He was charged with 6 misdemeanor assaults, 3 of those aggravated, 3 of those not, on the 25th of this month.
I was told those were all dropped down to a domestic.
Just a moment, sir. You can talk with your attorney.
One moment, I'll put you into a breakout room. Number 9, People versus Paul Precor, 23431 FH.
Good afternoon, Your Honor. On behalf of the people.
And good afternoon, Your Honors. I have on behalf of Paul Precor, who approaches the podium to my left. Come on over here.
Good afternoon.
State your name. Paul Precor.
Thank you. So today is the time and date set for the first pretrial. And counsel, you're aware that this docket is going to be transferred over to Judge Slay.
Yes, I am, Your Honor.
Okay, so how do you wish to proceed today?
Your Honor, I've had an opportunity to speak with the prosecutor. We do have a resolution. She emailed me a plea agreement, which I can email to the court after we put it on the record. And we would consent to entering the plea and being sentenced by Judge Slay.
Okay, and any objection to proceeding in that manner, Ms. Broughton?
None, Your Honor. And if the court would like, I can also email that plea agreement as well as the police reports. I believe this will be a no contest plea to the court.
Okay, any objection to her emailing me the material so I can establish a factual basis?
No objection, Your Honor. Thank you.
Okay, that would be fine then. So, sir, please raise your right hand to be sworn.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Could you please state your name again for the record?
Paul Precourt.
Thank you.
So, Mr. Precor, do you understand that if I accept your plea today, you would have to sign a sentencing judge waiver because Judge Ariane Slay will be handling your sentencing?
Yes, Your Honor.
Okay, and that's agreeable to you?
Yes.
Okay. Okay, so who wants to put the agreement on the record?
Ms. Broughton, go ahead.
Thank you. Sorry, I was multitasking, sending an email and putting it on the record. So, Your Honor, the agreement is as follows. With an added count 5, 6, and 7, all assault and battery, MCL 750-81, which is a misdemeanor with a maximum penalty of 93 days, the people would agree to dismiss counts 1 through 4, all of which are criminal sexual conduct in the second degree, state prisoner under MCL 750.520C1I. The maximum penalty on those charges is 15 years. The people would also agree to no upfront jail, and the assault and battery counts do not require SORA registration. I should also mention, Judge, that the victim is in agreement with this offer and would very much like for the case to be resolved in this way.
I see. Okay. And is that your understanding of the plea and sentence agreement?
That is correct. It would be no contest to the added A and B counts.
And the rationale for the no contest? Please?
Potential civil liability.
Okay. And is there any monetary penalty for those assault and battery charges? Potential?
Potentially, Your Honor, none of which are known to the people at this time.
Okay. So please raise your right hand to be sworn. You've already been sworn. Okay, that's fine. So I need to advise you, sir, that counts 5, 6, and 7 that are being added, each of those are assault and battery, which are misdemeanors punishable up to 93 days. Understood?
Yes, ma'am. Yes, Judge.
Okay. And you've had sufficient time to consult with your attorney about what to do in terms of accepting the offer and all?
Yes, Your Honor.
Okay. So there are a number of rights that you'd be giving up. If you enter these 3 pleas today, you have a right to a trial by a jury or by the court if all parties agree. You have the right to be presumed innocent and to have the prosecutor prove you guilty beyond a reasonable doubt. You have the right to have witnesses against you appear at a trial and to see, hear, and question those witnesses. You have the right to call witnesses to testify, and you can ask that the court order that witnesses appear for your trial. You have the right to remain silent and not have your silence used against you, and you also have the right to testify if you so desire. But if you enter these 3 pleas today, you would give up all of those rights. There wouldn't be a trial in this case, and the prosecutor wouldn't need to prove any of these allegations. Do you understand all of that, Mr. Precourt?
I do, Your Honor.
And do you still want to go ahead with the pleas?
Yes, I do.
So at the time of these offenses, were you on probation or parole?
No.
Are there any potential immigration consequences, counsel?
No, Your Honor.
No, Your Honor.
Are you aware of any, Ms. Broughton?
No, Your Honor.
Thank you. And so are you entering these pleas of your own free will?
I am.
Has anybody threatened or coerced you in any way to get you to enter the pleas?
No, Your Honor.
Has anybody made any promises or inducements other than what was stated on the record this afternoon?
No, Your Honor.
Are counsel aware of any threats or promises not on the record? Ms. Broughton?
No, Your Honor.
No, Your Honor.
And do you understand that by entering the pleas, you would be giving up your right to be able to argue to an appellate court either that pleading was not of your own free will, and you couldn't argue that there were some threats or promises that we didn't talk about today?
I understand, Your Honor.
Giving up your right to a direct appeal to an appellate court. So if you wanted to appeal from either your conviction or your sentence, you would have to ask permission from the appellate court, and we have no way of knowing what they would say about that.
Yes, Your Honor.
Okay, and finally, you would be waiving your right to appeal any issues that might have been available to you at the conclusion of a trial because you will not have a trial in your case. Understood?
I understand, Your Honor.
And knowing all of those things combined, do you still want to go ahead with these 3 pleas today?
Yes, Your Honor.
So turning your attention to September 7th, 2022 in Pittsfield Township, Washtenaw County at or near the Huron Valley Correctional Center. To added count 5, assault and battery, how do you plead?
No contest, Your Honor.
And to added count 6, how do you plead?
No contest.
And to added count 7, your plea?
No contest.
And let me just see what I've been forwarded here. And I should advise you, sir, that each count of assault and battery carries with it a potential financial penalty of up to $500. Understood?
Yes, Your Honor.
Okay. And you still want to go ahead with the pleas knowing that?
Yes, Your Honor.
Okay. So let me continue through this. And do counsel stipulate that the police report that I'm about to review does set forth a sufficient factual basis from which I can accept these 3 pleas?
The people stipulate, Your Honor.
So stipulated, Your Honor. Thank you.
Okay, and no objection to my review?
No.
Okay, just a moment. So I have reviewed that report and I am satisfied that it does set forth an appropriate factual basis from which I can accept the 3 pleas. Do you believe that I've complied with court rules, counsel?
The people do, Your Honor.
Yes, Your Honor.
I accept your pleas. I find them to be knowingly, voluntarily, and understandably made. I can set your sentencing for September 11th at 1:30 before Judge Slay. The court does expect all monetary obligations to be paid at the time of sentencing. Do you wish to be present for the pre-sentence interview?
I do not.
Okay. So you need to contact probation to make your appointment for your pre-sentence interview. You need to make sure you keep that appointment and provide them with all of the information that they request of you. So Judge Slay will be ready for your sentencing on September 11th. And all bond conditions continue to apply in the meantime. And Judge Slay does conduct her docket in person. Okay?
Very good, Your Honor.
Thank you, Judge.
You're welcome. Thank you.
Thank you, Your Honor.
To email the plea agreement. Would you like it?
I have that back. It may not be complete. When do I want what?
Or would you like him to send a copy of the plea agreement?
I typically don't get that, but I
didn't think you did.
okay. That's fine.
Recalling People versus Jonathan Franklin, 21425 FH.
Michael Doby, 50.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Franklin.
And have you had the opportunity to discuss this matter with Mr. Franklin?
I have, Your Honor. Thank you for passing the matter.
And so in terms of the allegations, let me go over those with you, Mr. Franklin. It's alleged in count 1 that you verbally antagonized Jeremy Fiore for over 3 hours, punching him in the face and kicking him in the head repeatedly on July 24th, 2023. Count 2 alleges that on the next day, July 25th, while at U of M hospital, you threatened to kick officers in the jaw, push a wheelchair at an officer, kick medical equipment, and asked females present to rub your genitals. Count 3 alleges that on that same date, you attacked a Samuel Bruce Klosky while he was sleeping on the sidewalk by punching and kicking him repeatedly, resulting in multiple lacerations and abrasions to his face and head. It's further alleged that on July 25th, you punched Sarah Humans in the face, knocking her to the ground, causing her to temporarily lose consciousness, and she sustained a small laceration on the back of her head. Count 5 alleges that on July 25th, you swung a closed fist at Mark Aulis and punched him in the face. Count 6, on July 25th, it's alleged that you open hand slapped Paul Wirtz in the face and threw a 6-foot metal pole, almost striking him. Count 7, on the same date, it's alleged you threw a 6-foot metal at Angel Martel, threatening to kill his dog and threatening to sexually assault his girlfriend. Count 8 alleges that you were not to use any object as a weapon, but it's alleged that you threw the 6-foot metal pole attempting to assault Paul Wirtz and Angel Martel. It's alleged that on that same day, you were displaying signs of being under the influence of alcohol, excessively sweating, with dilated pupils and an odor of intoxicants. Count 10 alleges that between July 24th and 25th, you committed the offenses of 3 counts of aggravated assault and 3 counts of assault and/or assault and battery, as reflected in Ann Arbor Police Department reports. So, Mr. Overwater, how do you wish to proceed today?
Your Honor, I'd ask to set the matter for the next available hearing date and to address the issue of bond.
And Judge Slay's next date?
Judge Slay's next date will be Tuesday. I'm sorry, will be Monday the 31st.
Monday, July 31st. And as to bond?
Your Honor, my client denies the allegations. He indicated that these are entirely fabricated. I did have the opportunity to observe both his face and his hands, which show no visible injuries of any kind, which one would think he would have based on the allegations the court just read. If he got into a brawl with 5 people and punched a number of people in the face, there'd be some sort of indication that he'd been in an altercation, and there don't appear to be. My client is indigent. He resides in Wyandotte. He did provide me with an address as well as a working phone number. He indicated he was in treatment, but he had issues with his insurance and Social Security that he's trying to resolve to get back into treatment. And he also is employed doing part-time residential construction. The misdemeanor matter is set for pretrial tomorrow, which is why I'm asking for the next available date. But I would ask the court to release him on a personal recognizance bond on these violations. He's currently held on a $25,000 cash or surety bond on the misdemeanor matter that's up tomorrow, but he's hopeful that that bond potentially could be reduced and he could secure his release.
Mr. Dobie.
Thank you, Your Honor. I ask that this defendant be remanded. This was a series of attacks on homeless people throughout the city of Ann Arbor, some of whom were sleeping at the time that they were attacked. Though Mr. Franklin says he has no wounds, I've seen the photographs of wounds to a number of the victims. It is true that he was arraigned on those 6 counts, and a $25,000 bond was set on that. It's my understanding he was also on probation to the 15th District Court at that time. So for all of those reasons, I ask that he be remanded.
For all of the reasons that Mr. Dobie stated, I am concerned about public safety, and I am remanding you pending your hearing before Judge Kunke on, pardon me, or Slay? Judge Slay on July 31st at 1:30. Good luck to you, sir.
Thank you, Your Honor.
You're welcome.
Number 6, People versus Heather List, 23406 FH.
Michael Dobie for the people.
Sandra White on behalf of Heather List. Ms. List, can you state your name?
Heather List. Okay, good afternoon. So today is the time and date set for the first pretrial. Ms. White, how are you proceeding today?
Your Honor, we're asking for an adjournment so that I can obtain additional discovery that I need to request from Mr. Dobie.
And how far out do you need?
There is a co-defendant on this case who has the date of the 31st. I don't know if you want to go out to the same date. Mr. Dobie, would you like those on the same date?
That's fine.
The 31st of July?
August, she said.
August. Okay.
Oh, that's a Thursday.
Okay. And you know this case is being transferred to Judge Slay, Ms. White?
Wait, let me see your doing now. Hold on.
Ms. White?
Yes, I'm sorry.
Okay, so she does handle her docket in person, so that's at 1:30 on August 31st. Ms. List, you need to appear in person for that hearing. Anything further for today?
Your Honor, when I receive that list of additional requested discovery, I will endeavor to provide that.
Okay. And all bond conditions continue to apply in the meantime. Thank you.
Thank you. Thank you.
On the supplemental, People versus Renee Mills, 17693 FH.
Good afternoon, Your Honor. Coordinator, and today's the date and time for the collections bench warrant for Mr. Mills, who is appearing from.
Good afternoon. Ms. Mills, please raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes. Yes.
Can you state your name for the record, please?
Renee Mills.
Thank you.
Ms. Mills, you're before the court on allegations that you should be found in contempt for your failure to appear for a show cause hearing before, I believe, Judge Slay on, well, actually, at that time, it would have been Judge Brown on March 16th, 2022. Maybe it was Judge Slay, I'm not sure. But in any event, and that hearing was set because it's alleged that you failed to pay $2,950.80 on your financial assessments. So have you had an opportunity to talk with Ms. Mills, Mr. Heatherbridge?
I've not had an opportunity to speak with Ms. Mills yet. I know that the next classification date in X jail is September 24th of 2023. So I'm not sure if she's being held on something other than this specific collections warrant. And I don't know if Mr. Overwater's had an opportunity to speak with her or not.
I did speak with her. She's held on a number of other misdemeanor matters. So this is not the only thing holding her here. Those matters were set for arraignment today. Indicates the bond is set at $5,000, 10% on 6 cases plus 550 on a 7th one. So I don't know if she's going to be securing her release or if she's going to be here for a bit of time. I did speak with her, and she did express interest in. Actually, I know there are late fees assessed as well as waivable costs. Considering the amount of new cases she has to deal with, she would ask the court if the court would be willing to waive any waivable fines and costs in this matter.
And
well, I would waive any late fees that are still outstanding, Mr. Petherbridge.
I was just going to say, Ms. Mills also has 3 additional cases in our court with $0 paid to date. So that's just a FYI. And based on the fact that she's incarcerated at this point in time, I'd just be willing to dismiss these hearings with the understanding that she just needs to contact me when she gets out, and we can talk about seeing what we can get waived. Like I said, the late fees, I can submit some orders for that, and then we can kind of go from there with Judge Slay.
So, Ms. Mills, would you agree to contact Mr. Petherbridge if I allow you to be released?
Yes, Your Honor.
Okay, so when you're released from jail, you need to contact Mr. Petherbridge. Thank you for your willingness to dismiss this for today so she could address the other matters, the criminal part of it.
Thank you, Your Honor.
Okay, good luck to you, Ms. Mills.
Thank you.
Mhm.
Number 4, People versus Maurice Robinson, 22400 FH.
Kenneth Overwater, Assistant Public Defender, on behalf of Mr. Robinson, who's present by Zoom.
And Mr. Robinson, can you hear me?
Yes, ma'am.
Okay. Mr. Doby, or, oh, if this is a Attorney General case.
Good afternoon, Judge. Carrie Angie appearing on behalf of the Michigan Attorney General.
Good afternoon. So today is the time and date set for the adjourned final pretrial. How are we proceeding, counsel?
Yeah, at this time, my client wishes to enter a plea. We do have a plea agreement, and that would be that he would plead guilty as charged. The habitual offender fourth notice would be reduced to an habitual second. And further, we would have a sentence agreement of probation with no additional upfront jail. And Mr. Robinson would be ordered to pay his monthly obligation, which is, I believe, $62 a month.
Zanj?
That is correct, Your Honor. Counsel makes a full and accurate statement of our agreement.
Okay, so please raise your right hand to be sworn, Mr. Robinson.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Can you please state your name for the record?
Maurice Robinson.
Thank you.
Mr. Robinson, did you hear and understand the statements that the attorneys just made?
Yes, ma'am.
And do you want to enter a plea in accordance with those agreements?
Yes, ma'am.
So then with the habitual offender being reduced to a habitual second, your child support would be, or count one, failing to pay child support would be a felony punishable by up to 6 years. Is that correct?
Yes. Yes.
As the habitual second, counsel?
Yes, Judge, that is correct.
Okay. And there are a number, and or $2,000. There are a number of rights that you'd be giving up if you enter this plea today. You have a right to a trial by a jury or by the court if all parties agree. You have the right to be presumed innocent and to have the prosecutor prove you guilty beyond a reasonable doubt. You have the right to have witnesses against you appear at a trial and to see, hear, and question those witnesses. You have the right to call witnesses to testify, and you can ask that the court order that witnesses appear for your trial. You have the right to remain silent and not have your silence used against you. And you also have the right to testify if you so desire. But if you enter this plea today, you'd give up all of those rights. There would not be a trial and the prosecutor wouldn't need to prove any of these allegations. Do you understand all of that, Mr. Robinson?
Yes, ma'am.
And do you still want to go ahead?
Yes, ma'am.
And have you had sufficient time to consult with your attorney about what to do here today?
Yes, ma'am.
And I need to mention that the case is going to be transferred to Judge Slay, Ariane Slay. So I would need to have Mr. Robinson execute a sentencing judge waiver. Mr. Overwater, have you been able to address that issue with your client?
I believe we discussed, Mr. Robinson, you understand that Judge Slay will be the judge to sentence you pursuant to the agreement that you've reached with the Attorney General?
Yes, ma'am. Yeah.
And you accept that?
Yes.
Okay, so we will need that sentencing judge waiver. So at the time of this offense, were you on probation or parole?
No.
Are there any potential immigration consequences, counsel?
No, not aware.
Okay, so are you entering this plea of your own free will?
Yes, ma'am.
Has anybody threatened or coerced you to get you to do so?
No, ma'am.
Has anybody made any promises or inducements other than what was talked about here on the record today?
No, ma'am.
Are counsel aware of any threats or promises not on the record?
No, Judge.
Judge, I'm not, but reviewing my notes, I believe his monthly obligation is actually $63, not 62.
Okay, Mr. Robinson, do you understand that?
Yes, ma'am.
Okay, and that would be agreeable to you?
Yes, ma'am.
Okay. So, do you understand, sir, that by entering a plea, you would be giving up your right to be able to argue to an appellate court, either that you couldn't tell them that there were some promises or inducements or threats that we didn't talk about, and you couldn't argue to them that pleading was not of your own free will, understood?
Yes, ma'am.
And you'd be giving up your right to a direct appeal to an appellate court. So if you wanted to appeal from either your conviction or your sentence, you would have to ask permission of the appellate court, and we have no way of knowing how they would respond to that.
Yes, ma'am.
And finally, you would be waiving your right to appeal any issues that might have been available to you at the conclusion of a trial, because you won't have a trial in your case, understood?
Yes, ma'am.
And knowing all of those things combined, are you still wanting to enter this plea today?
Yes, ma'am.
So, and I'm not sure if I asked, are there any potential immigration consequences, counsel?
You did, Judge, and no, there are not. Thank you.
None that I'm
Okay.
aware of, Judge.
Okay, thank you. So turning your attention, sir, to the time period between September 1st, 2021 and December 31st, 2021, to count one, failing to pay child support as a habitual offender. Second, how do you plead?
Guilty.
Tell us what you did that makes you guilty of that offense.
Mr. Robinson, during that time period, were you under an order to pay child support to Melanie May?
I don't even know a Melanie.
Your Honor, if I may, the victim's name is Shakina Londe Lowry.
Yes.
Thank you. So you were ordered to pay child support to Ms. Lowry?
Yes.
And during that time period, did you miss at least one payment?
Yes.
I'm satisfied, Your Honor. Oh, additionally, on March 22nd, 2018, were you convicted of the offense felon in possession of a weapon?
Yes.
I believe that lays out the factual basis, Judge.
Ms. Ange?
Briefly, Judge, thank you. Sir, that order for you to pay child support came out of Washtenaw County, is that right?
Yes.
And you would have no reason to dispute the case number in that order is 071435 DP.
No.
Thank you, Judge. I'm satisfied.
Mr. Overwater?
I'm satisfied, thank you.
Do you believe I've complied with the court rules?
I do, Judge. Thank you.
Yes, Your Honor.
I accept your plea. I find it to be knowingly, voluntarily, understandably, and accurately made. I can set your sentencing for September 11th at 1:30. Is that agreeable, counsel?
It's good for me, Judge. Thank you.
That's good for me, Judge.
Okay, and that would be before Judge Slay. She is handling her dockets in person, so you need to appear in the courthouse on September 11th before Judge Slay, and all bond conditions continue to apply in the meantime. The court does expect all monetary obligations to be paid at the time of sentencing. Mr. Overwater, do you want to be present for that pre-sentence interview?
Yes, please.
Okay. Anything further for today, counsel?
Judge, is that in-person mandate applicable to the Attorney General's office as well?
That's something you'll need to take up with her chambers. I cannot give you an answer. I'm sorry.
Indeed, thank you.
Okay, thank you all.
And the jury trial date is stricken now, Judge?
Yes, jury trial is now canceled. That was previously set for August 14th. Okay,
Thank you, Your
thank you.
Honor.
On the supplemental docket, People versus Michael Shantz, 20498 FH.
Michael Doby for the people.
And Mr. Shantz, please raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
Can you state your name for the record, please?
Michael James Shantz.
Thank you.
Mr. Shantz, you're before the court on allegations that you violated your probation. You're entitled to a contested evidentiary hearing. The maximum potential penalty is 5 years. Can you afford to hire your own attorney this afternoon?
No, I can't. I don't have the money for that.
So I'll appoint the public defender to represent you. The allegations are that on May 11th, 2023, that you angrily pushed your roommate and his head struck a wall, and that you were arrested by the Ypsilanti police with a pending assault and battery case in the A2 District Court. It's further alleged that on May 11th, you admitted to police that you pushed your roommate, Demetrius Robinson, into a wall, causing him to hit his head. So, Mr. Overwater?
Judge, Mr. Shantz must have turned himself in later this morning, so he was not on the list either when I was at the jail. So I didn't have an opportunity to meet with him yet. I would ask the court to set this matter for a hearing, particularly if he has a new offense, which I don't see in X jail. So I'd be asking just to adjourn this matter and for the court to consider releasing him on a personal recognizance bond. The allegations are certainly concerning, but it is a misdemeanor offense. And Mr. Shantz, did you turn yourself in today?
Yes, I did. And I moved out of that property as well. I'm now living at my mom's house, so.
So it looks like there's no issue with him having contact with that complaining witness. He did turn himself in on this warrant, Judge. I'd ask the court to release him on a personal recognizance bond.
Mr. Doby?
Thank you, Your Honor. Just I'll note that that case is pending in the 14A2 District Court. He is charged with assault. The next hearing on that is on the 2nd, so next Wednesday. Regarding bond, I'll leave that to the court.
So he has bond set in the district court on those cases, or that case, Mr. Overwater?
Yes, Your Honor, according to my notes, there's no notes. But it's my understanding, yes, that he is admitted to bond on that matter. I can pull that up.
I believe it's a personal recognizance bond.
So, sir, do you agree to return to the court for your hearing on next week?
Yes, ma'am.
Okay.
He is released on bond, Your Honor. The EIS doesn't specifically indicate that it's a PR, but it does indicate that there are pretrial bond conditions in effect through July 12th of 2024.
Okay, so if he's having his hearing on August Second, could I set this before Judge Slay on August 3rd?
Is she having a document on August 3rd, Judge?
I don't believe so.
No?
On August 3rd, she's
Oh, apparently she's not.
not taking those over until the 7th. So her next available for you would be
Ah.
August 10th.
Oh, okay, that's right. So I'm not available on the 3rd, and she is available on the 10th.
I don't have
So
an
do you
objection
want,
to the 10th.
okay. August 10th at 1:30 before Judge Slay. I will allow you to be released on a $500 personal recognizance bond. So if you don't appear in person before Judge Slay at 1:30 on August 10th, you're going to owe the court that money. Understood, Mr. Shantz?
Yes, ma'am. Yes, ma'am.
Okay. And no assaultive or abusive behavior in the meantime. And the condition of your probation, I presume, is not to use or possess alcoholic beverages or non-prescribed controlled substances. So be sure to abide by that as well. Okay?
Yes, ma'am.
Okay.
Thank you.
You're welcome.
Have a good day.
Take care.
What's that?
Yeah.
Okay. All right, come on.
Number 13, People versus Cleo Major, 23450 FH.
Michael Doby for the people.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Major.
Good afternoon, Mr. Major. Can you hear me?
Yes, I can hear you.
Okay, so today's the time and date set for a pretrial. Mr. Overwater?
Your Honor, we were in negotiations on this matter. Mr. Doby and I were talking into the evening yesterday. We've exchanged some counter offers. The latest offer was presented to Mr. Major last night. We discussed it this morning. He's asking for some additional time to consider that offer and how he'd like to proceed. I'd ask to adjourn this matter to August 17th.
No objection.
I do find good cause for that adjournment. I am adjourning your case, Mr. Major, to August 17th. It's going to be handled by Judge Ariane Slay. You need to appear in person for your hearing before Judge Slay on August 17th at 1:30. Thank you. And all bond conditions continue to apply in the meantime. I'm sorry, what did you say, sir?
Is that, will that be 15 District Court?
And 22nd Circuit Court
22nd Circuit Court, okay.
at Maine and Huron, second floor, courtroom 3. Four. Courtroom 4. Thank you.
Okay, thank you so much, sir.
Uh-huh.
Number 29, People versus Gerald Washington, 21501 FH.
Michael Doby for the people.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Washington.
Hi, Gerald Washington here.
Good afternoon. So today is the time set for the violation hearing. Mr. Overwater.
Yeah, we've reached a resolution on this matter. There was a possibility of new charges being filed. Mr. Doby has confirmed with me that new charges will not be filed against Mr. Washington. And probation is recommending that he be reinstated with the conditions that he continue to engage with his recovery coach, that he stay on the Scram Tether for the remainder of his probation term, and that he comply with the outpatient treatment that he's currently doing at Dawn Farm.
Is all of that your understanding, Mr. Doby?
Yes, I'm not aware of what the recommendation from probation is, so if that's any different, I'll ask Mr. Pollard to chime in, but I will confirm that I denied the new warrant request.
Yeah, yes, that is the recommendation from probation.
Okay, thank you. So, Mr. Washington, please raise your right hand to be sworn.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Could you state your name again for the record, please?
Gerald Ambrose Washington.
Thank you.
Mr. Washington, did you hear and understand the statements that the attorneys just made?
Yes, I do.
And do you want to admit these allegations on the understanding that I would sentence you in accordance with probation's recommendation?
Yes, I would, Judge.
Have you had sufficient time to consult with Mr. Overwater about what to do here today?
Yes, I have.
Okay. So if you admit these allegations, you understand that the maximum potential penalty is 2 years, and that you wouldn't have a contested evidentiary hearing.
Yes, I do, Your Honor.
Okay. So is it true, sir, that between May 28th and May 29th, according to the Michigan State Police, you made approximately 11 or 12 phone calls to Washtenaw County Central Dispatch advising the operator that you were going to kill your nephew, and that you called your niece many times, again threatening to kill your nephew?
Judge, I'd ask that he plead no contest to that allegation.
Any objection? Okay, so as to the factual basis, would you counsel stipulate that the allegation in paragraph 1 suffices?
Yes, Your Honor.
Yes, Your Honor.
Okay. And the second allegation, it's alleged that you consumed alcohol on or about May 28th, 2023. Is that correct?
Yes, Your Honor, I did.
Okay, and just so the record is clear, as to number 1, are you pleading no contest?
Yes, I am, Your Honor.
Okay, and then number 3, it's again alleged that you made the 11 to 12 calls advising dispatch you were going to kill your nephew. So are you also pleading no contest to number 3?
Yes, I am, Your Honor.
And counsel, are you also stipulating to the allegations setting forth the factual basis in number 3?
Yes, Your Honor.
Yes, Your Honor.
Okay. And as to sentencing, Mr. Overwater?
Your Honor, I'd waive a new report. I'd ask the court to proceed to immediate sentencing.
Mr. Doby?
I have nothing to add. Thank you.
Mr. Overwater?
Your Honor, the court's well aware of Mr. Washington and his struggles with alcohol. He has completed residential treatment. He's in outpatient treatment now. He's staying at Friends of the Master in a sober living facility with a lot of support. So he's doing well. Obviously, the challenge with substance abuse for all people is maintaining that sobriety, but he's on the path and he's doing well right now. So I know Mr. Washington is very appreciative of the recommendation that the new charges were denied. And he's going to keep working on it.
Mr. Washington, is there anything you want to tell me before I impose sentence?
No, I just wanted to add that I was also doing the medical Vivitrol shot. I know you've asked me that in the past, so I did go to Packard Health, and I'm also doing that. So.
Well, I am going to adopt probation's recommendation. I know that it's a difficult road, but you really have to commit to maintaining your sobriety going forward, because when you don't, Nothing good comes of that, as you know. So I am going to reinstate you on probation under the same terms and conditions. However, you must continue with your recovery coach, continue with the SCRAM monitoring for the remainder of your probation, and complete the Dawn Farms program and all aftercare that they recommend for you. You're entitled to file an application for leave to appeal from your conviction and sentence. If you can't afford an attorney, one can be appointed for you for purposes of appeal. However, the request for appointment of appellate counsel must be filed within 42 days of today's sentencing. And how will you transmit that form to Mr. Washington?
I will email that to him today, Your Honor.
So look for that in your email, sir. Good luck to you.
Thank you, Your Honor. Thank you, Ken, and thank you.
You're welcome, Jerry. Thank you, Your Honor.
You're welcome.
On the supplemental, People versus Reginald Johnson, 22364 FH and 22365 FH.
Michael Doby for the people.
Kenneth Overwater, Assistant Public Defender, on behalf of anticipating appointment on behalf of Mr. Johnson.
Mr. Johnson, please raise your right hand.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Can you please state your name for the record?
Reginald LaShawn Johnson.
Thank you.
Mr. Johnson, you're before the court on allegations that you violated your probation. You're entitled to a contested evidentiary hearing. The maximum potential penalty is 5 years. Can you afford to hire your own attorney this afternoon?
No, ma'am.
I'll appoint the public defender to represent you. The first allegation is that on July 1st of this year, you were arrested for non-aggravated assault or simple assault, and charges have been authorized for domestic violence with the pretrial scheduled in the First District on August 21st. It's further alleged that, according to the Monroe Police Department, on July 1st, you were arrested for non-aggravated or simple assault, and you never reported that police contact to probation. Third, on June 26th, it's alleged that probation sent a drug testing referral to Washtenaw Community Corrections and that you failed to appear for your testing. Fourth, you were not to use alcoholic beverages or other intoxicants, but it's alleged that on July 1st, it was reported that you consumed alcohol, according to the Monroe Police. And fifth, it's alleged that you struck Quinata Johnson in the head 3 to 4 times, leaving her with a bump on the left side of her forehead. And that's in each of your 2 cases. Same allegation. So at this time, Mr. Overwater, how do you wish to proceed?
Your Honor, I'd ask to set the matter for a hearing before, I believe it's Judge Kunke, and to address the issue of bond.
And as to bond.
Thank you, Your Honor. My client denies the allegations out of Monroe, and he does look forward to fighting those allegations in court and being found not guilty or having the matter dismissed. As far as the testing, he indicated to me that he was in contact with his probation agent and he had exchanged the information, and he was advised that his agent or someone else would reach out to him and tell him when he needed to test. He indicated that call never came. So he was under the impression that he didn't have to until he was told to. My client's disabled. He collects SSI. He did provide me with an updated address. He's residing in Carlton, Michigan. but he does have an apartment, and if he is incarcerated, he will lose that. So I would ask the court to consider releasing him on personal recognizance bond on these matters so that he can appear before Judge Kunke on Tuesday.
So how did he come to the attention of the authorities now?
Mr. Johnson, did you turn yourself in or were you transferred here from Monroe?
I was transferred from Monroe.
Mr. Dobie, as to bond?
Thank you, Your Honor. I'd ask that the defendant be remanded on this case until he can appear before Judge Kunke next week. At least in looking at the file on Odyssey, I also see that he failed to appear for a probation violation hearing on the 11th. And there is also a bench warrant for that. On that and the other warrant, Judge Kunke has indicated no bond. And I agree that with the new arrest for assaults and the other issues laid out in the warrant, remand is appropriate.
Judge, if I also may add, he was kicked out of drug court for lying about where he was residing, and he also violated his curfew tether. So probation would recommend he be remanded.
Okay, and for all of those reasons, I am remanding you pending your hearing before Judge Kunke. I am concerned about public safety with some of these allegations. So the next available date is August 1st. That is a very busy docket. Is that the date you want?
Yes, Your Honor.
Okay. And that's before Judge Kunke at 1:30. So you are remanded pending that hearing. Good luck to you, Mr. Johnson.
So what is that? I stay in jail, no bond?
Yes, until next week.
Well,
At least until
your
August
next
1st.
hearing.
Until August 1st?
Okay.
Number 18, People versus Mylan Patton, 22166FH.
Not the Overwater Assistant Public Defender on behalf of Ms. Patton.
Good afternoon, Ms. Patton. Can you hear me?
Yes, ma'am, I can hear you.
So today's the time and date set for your sentencing. You are entitled to an in-person sentencing. And we are proceeding this afternoon by Zoom. Do you have any objection to being sentenced by Zoom, Ms. Patton?
No, ma'am.
Okay, Ms. Ange.
Good afternoon, Judge Carrie Angie, appearing on behalf of the people. We likewise have no objection to a Zoom sentencing today. Thank you.
Thank you. And Mr. Overwater, do you?
I do not.
Okay. So, Mr. Overwater, have you reviewed the pre-sentence report with your client?
Yes, Your Honor, we do have a couple things to point out. One, the Delaware, Ohio Municipal Court case, my client indicates that that matter was resolved, I think, earlier this week and is now closed.
Any objection to taking that off the pending portion of the report?
I would only inquire as to the disposition of the matter.
Ms. Patton, that was dismissed, correct?
Yes, ma'am. Yes, sir. I'm sorry.
Judge, I would object to it being removed from the report, being that the only information that we have regarding it comes straight from the defendant herself.
Is there any update that probation has, Mr. Pollard?
No, Judge, at the time we submitted this PSI, that was a pending matter, so I do not have a recent lien. So I can verify that it's been dismissed.
Well, I'm going to leave it there, but I'm not going to consider it in terms of my sentence.
And then additionally, Your Honor, my client denies the larceny by conversion case that's alleged out of 16th District Court. I'm actually.
I sent you the thing on your.
I know you did.
Oh, okay.
So it says 16th District Court on the front page, but on page 4, with that case number, it indicates that it's out of Macomb County, so it would be 16th Circuit Court, and that is a Circuit Court case number, so I think it should say 16th Circuit Court. Furthermore, when I tried to look that matter up in the 16th Circuit Court website, both by my client's name and by the case number, I couldn't find anything, so I don't know why that doesn't come up. But additionally, there's no conviction. I don't know if it's pending. I'd at least ask the court not to consider it, and then her and her probation agent can try and figure out why it's popping up in her lien.
Have any information about that, Ms. Angie?
Are we talking about the offense date of August 4th, 2017, Mr. Overwater?
Yes, I believe we are.
I don't have any information on that. I noticed that probation did indicate NA in the areas of conviction and sentencing. So I am without information.
Judge, I have a lien here and it does show an arrest for that under the arrest segment, charge segment, but there is no judicial segment information. But it does appear to be the defendant that was arrested for that incident. And it is a pending matter according to lien.
So there was an arrest but no conviction. And you don't want it shown on the front page, is that it, Mr. Overwater?
Ideally, Your
As
Honor, yes.
pending? Okay, well, it does appear on lien, so without further documentation, I'm going to leave it there. But I'm not going to consider it in terms of the sentence that I'm going to impose, which is the sentence agreement that counsel agreed to.
Thank you, Your Honor. And then on page 8, under family, where my client's mother indicates that my client was hospitalized at Havenwick for oppositional defiance disorder and after lying about being pregnant to keep a boy. My client denies that.
All of it?
That
All of
entire
it.
sentence.
Okay, baby, you want some more coffee?
So Ms. Angie?
Your Honor, I would simply ask that that information remain in the PSI, since once again, the only information that we have in denial of it is from the defendant herself. And the probation officer was speaking to her mother who made these statements. So I would ask that they remain present.
There is a source of information stated, so I'm not going to strike it, but I'm not going to consider it in terms of my sentence today.
Judge, I'm just asking that a sentence be added that Ms. Patton denies those
I
allegations.
can do that. I can add that sentence.
Thank you, Your Honor.
Okay, anything else?
I have nothing further, Your Honor.
Okay. Ms. Angie, do you have any additions, corrections, or deletions to the report?
I don't, Judge. Thank you.
Okay. And as to the sentencing guidelines, do you believe that they're appropriately scored at 0 to 9 months, counsel?
I do, Judge. Yes, thank you.
I apologize, Judge. Yes. Yes, I believe they are correctly scored.
Okay. So anything further, Ms. Angie?
I would only request, Judge, that an additional term be added to the probation requirements. I note that one of the requirements is to pay child support and related expenses as ordered by the court. I would simply ask that the court either modify that or add a number 18 indicating that restitution in this matter is the arrearage of $17,068.73. I know probation is recommending 5 years of probation. I divided $17,068.73 over a period of 60 months. I came up with $284.48 a month. We would be asking the court to require that restitution be paid in that amount, 17,068.73 at $284.48 a month to ensure the arrearages are paid off by the time probation expires 5 years from now.
Thank you. Mr. Overwater.
Judge, I don't have an objection to that. I'm sure probation will work with her if she's struggling at any particular time, needs to make up ground on the payments. I know she's working with child's father to try and reduce the monthly obligation so that she can make more headway on the arrearage, and they are working to co-parent better. And she's also working to clarify what the actual parenting time is with the court handling that matter. I would just, beyond that, I would ask the court to sentence my client pursuant to the to the agreement that we've reached. And I have nothing further to add.
Okay, Ms. Patton, is there anything you want to tell me before I impose sentence?
No, ma'am. No, I'm okay.
Okay, so we need to decide on a goal for Ms. Patton's probation, and I was going to suggest maintaining employment so that she can make regular monthly child support payments.
No objection, Judge.
Ms. Angie?
Judge, thank you. I do think that is appropriate. I do want to note for the record that Mr. Christopher Patton is the victim in this matter. I spoke with him in advance of the hearing, informing him of his rights under the Crime Victim Rights Act. He's asked me to speak for him today. And I just want to note for the record that this defendant's failure to follow the court's order has imposed a significant financial hardship on Mr. Patton, who found himself supporting these two children all by himself while these $17,000 in arrears accrued. The current order is for $308 a month. And hopefully with the court's sentencing today, the issue of the outstanding amount and defendant's failure to pay will be resolved by her paying the $308 a month plus what the court will order her to pay in restitution of $284.48 a month. And beyond that, the parenting time issues obviously have nothing to do with this criminal felony prosecution. And so I would just say on behalf of Mr. Patton that he's happy to see this matter come to a close and that he hopes this defendant follows the court's order finally so that she doesn't find herself in violation of probation and possibly going to jail.
Okay. Thank you.
Thank
you. On count one, failing to pay child support, I am sentencing you to 5 years probation subject to a number of special terms and conditions that I'm going to just briefly summarize. You must not use or possess alcoholic beverages or non-prescribed controlled substances, and you must comply with any testing, any treatment, and any assessments of any sort when you're directed to those. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not change your residence without getting written notice written permission, excuse me, from your field agent. You must allow the agent into your residence at any time for probation supervision and submit to a search of your person and property, including but not limited to your vehicle, residence, and computer, if the agent has reasonable cause to believe that you have items that would violate the conditions of your probation. You must pay the $60 DNA fee, $68 state costs, and $130 crime victim assessment. I'm not imposing the other financial obligations because she's deemed indigent at this time. However, you must pay child support and related expenses as ordered. And I am going to rely on the friend of the court to set the amount of the payment on her arrearage. And you must make your payments via MSDU. I understand that the total balance is just over $17,000. I am not going to impose a specific amount because of the current monthly of $308. So you must pay as directed on the arrearage. And you must waive confidentiality so that friend of court can report to your agent on what the current orders are and what your payments have been. You're entitled to file an application for leave to appeal from your conviction and sentence. If you can't afford an attorney, one can be appointed for you for purposes of appeal. However, the request for appointment of appellate counsel must be filed within 42 days of today's sentencing. And Mr. Overwater, how will you transmit that form to your client?
I've emailed that to her already.
Okay, good luck to you, Ms. Patton.
You.
You're welcome.
Thank you, Your Honor.
You're welcome.
The next hearing is a non-public hearing. The court will return shortly. Number 12, People versus Michael Brooks, 23420 FH.
Jessica Blanchard. People.
Sandra White on behalf of Michael Brooks.
Good afternoon. And Mr. Brooks, can you hear me?
Yes, ma'am.
So today is the time and date set for the pretrial. Ms. White, how are we proceeding?
Your Honor, we would like to adjourn so that we can get the preliminary exam transcript.
Okay, and how much time do you need for that?
I don't know how long. I think it's been taking about 3 weeks to get them.
So I could put that on for, do you want August 17th or the 24th?
The 24th.
Is that agreeable?
Yes, Your Honor.
Okay, adjourn to August 24th at 1:30, and that's going to be before Judge Slay. The case is being transferred, so she is conducting her docket in person. Thank you.
Thank you, Your Honor.
Uh-huh.
Thank you.
You got transferred.
Yes.
What is that?
Number 30, People versus Keith Valentine Jr., 18924 FH.
As Overwater Assistant Public Defender on behalf of Mr. Valentine, who I don't believe is present, Your Honor. I received a message from Mr. Petherbridge indicating that Mr. Valentine has executed the promissory note, so I would ask that he be discharged from probation.
No objection.
Okay, discharge from probation. So I'll sign that discharge when it's sent up. Okay, thank you.
Yes. Thank you, Judge.
Numbers 5 and 34, People versus Damaris Hunter, 21492 FH.
Michael Doby for the people.
Good afternoon, Your Honor. For the record, Stuart Collis on behalf of Damaris Hunter.
Good afternoon. Ms. Hunter, can you hear me?
Yes, ma'am.
So today is the time and date set for the adjourned pretrial. And counsel, you're aware that this case is being transferred to Judge Slay.
Yes, Your Honor.
Okay. Is there anything else for today?
Yeah, there is.
Mr. Collis?
On my behalf, no, Your Honor.
Okay.
Your Honor, I filed a motion to remove my counsel.
And what is the basis for that motion?
Because he's biased. He's
He's what?
He's biased, and he's not representing me to the best of my ability. To the best of my ability, I do not believe so. I submitted an email of him being biased in my email, and I've been trying to get my mental state aware of the courts to be aware of my mental state, and he's just not representing me to the best of his ability. I've been contacting him, I've been talking to him, and he refers to me as the getaway driver and my ex as a murderer, and I don't like that, and I just don't want him on my case anymore. I don't agree with him and his ways of doing things and the way that he talks to people, and I'm actually in the motion of filing a grievance against him with the Attorney Grievance Commission.
Mr. Collis, did you wish to respond?
Yes, Your Honor. Let's for the court to understand this, I think it needs to go back a little bit, but Ms. Hunter and I have been working together now for about 2 years. I've represented her extremely well. She was showed up drunk at the preliminary exam and was held in contempt or had 3 contempt hearings, which I got all 3 eventually dismissed before one of the co-defendants was bound over. Furthermore, Your Honor, we had made a deal with Mr. Doby where I would give, and I have it in writing, and Ms. Hunter has a copy of that in her possession, whereby she's granted immunity as long as she testifies against the co-defendant and her case will be dismissed, which is why this case keeps getting adjourned, because she is the star witness or at least a star witness in the Parker Adams case. So in every single instance, I've represented her really well. However, Ms. Hunter does not want to testify, and I've explained Ms. Hunter on a number of different occasions that she can't just submit a letter, she can't submit an affidavit, and that's what she wants to do. Because
I'm not trying to get out of my
Ms. Hunter,
agreement,
this is my
so-
turn to talk.
Okay, whatever.
She swears at me in emails. She's very rude, but nonetheless, I've gotten her the best result that she could possibly hope for, which is eventually a dismissal as long as she complies. I don't know how I could do any better of a job for an individual than this, yet apparently I'm never good enough. So if the court sees fit to remove me, that's fine. I have no objection to doing so. I don't know if eventually what good or bad it would do, because like I said, she has a deal for immunity and her case will be dismissed as long as she testifies. So there's nothing for me to do in this case except continue to adjourn the case until a trial on the co-defendant occurs.
Okay, and
Your Honor, can I rebuttal?
excuse me just a moment. Mr. Doby, are you taking a position here?
No, Your Honor, as the matters between the defense counsel and his client, I take no position. I will say that regarding the plea deal, Mr. Collis did negotiate that, and his recitation of that is correct.
Okay, and that plea deal is not contingent on which attorney is representing her, correct?
That's true.
So even if a different attorney was appointed, she would continue to have that same plea deal, and that requires that her case pend until Mr. Brooks' case is resolved. Is that correct?
That is correct, Your Honor. It would get no better or worse under a new attorney.
Okay, so, I agree with Mr. Collis that it sounds like this is a very good result for you, Ms. Hunter. And a indigent defendant is entitled to appointment of a lawyer at public expense, but not entitled to choose their own lawyer. And I can only change an attorney based on adequate cause. And the right to substitute counsel does require a showing of good cause, even though you may lack confidence in Mr. Collis, even though you may file a grievance. Those things aren't sufficient. But what concerns me is her allegations of her mental state. She believes that Mr. Collis is biased against her. So for her mental health, I'm going to allow you to be replaced by another appointed attorney, Mr. Collis. Thank you for your representation of her up to this point. So the Indigent Defense Commission will appoint another attorney to represent you, Ms. Hunter, unless you engage your own counsel of your own choosing at your expense. So I hope this matter is ultimately resolved to your satisfaction. Thank you.
Thank you very much, Your Honor.
We need a new date for the pretrial. Does anybody know when Mr. Brooks' case is up next?
It's up for trial on September 25th. I don't know off the top of my head the pretrial date. If there is a pretrial date.
I would suggest, Your Honor, I know I'm not Ms. Hunter's counsel anymore, but I mean, Mr. Doby and I set up this date with the understanding we were going to check where Mr. Brooks's case was, and I apologize for earlier saying Adams. Different case, different co-defendant. But in any event, I would suggest that we do it at a date either after that final pretrial or trial, so that Ms. Hunter may not have to appear again.
Okay.
The final pretrial looks like it is on September 7th.
So do you want this set before Judge Slay on September 11th?
Mr. Doby?
Yes, Your Honor. I'm sorry. Yes.
Okay, so I'm going to adjourn this pretrial to September 11th, and that will provide time for the indigent defense counsel to appoint someone to represent you. Thank you.
Thank you very much. I'll contact Ms. Hightower.
Oh, and Ms. Hunter, by the way, Judge Slay does hear her cases in person. So your next hearing for September 11th at 1:30, you must appear in person at the courthouse courtroom number 4.
Number 4. Can you tell me exactly where that's at? Because I'm not familiar with Ann Arbor.
Maine and Huron.
Okay, yes, ma'am.
Second floor, courtroom 4. Thank you.
Okay, thank you.
Thank you very much, Your Honor. You have a great day.
You too.
Thank you. Thank you, Mr. Doby.
Thank you, Mr. Kellis.
Number 22, People versus James Huizenga, 23165 FH.
Michael Doby for the people.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Huizenga.
Mr. Huizenga, good afternoon. Can you hear me?
Yes, ma'am, I can.
So today is the time and date set for your sentencing. You're entitled constitutionally to an in-person sentencing. Are you waiving that right to proceed by Zoom this afternoon?
Yes, ma'am, I did that in the courtroom as well. Yes, ma'am.
Thank you. And counsel, any objection to proceeding in this manner?
No, Your Honor.
No, Your Honor.
So we don't have a pre-sentence report. Mr. Huizenga was convicted of the domestic violence by the jury, which is a misdemeanor. So as to sentencing, Mr. Doby?
Thank you, Your Honor. In this case, I am asking that the court impose a term of probation, given the nature of the offense for which he was convicted, the domestic violence second offense. There's not a victim impact statement to be given today, but I would ask for standard terms of probation and no contact with the victim.
Okay. And now he was convicted of domestic violence, and it was charged as a domestic violence second offense. Is that how we're just proceeding on the domestic violence, correct?
No, Your Honor, it would be as a second offense. However, there was a issue, and we amended on the record before the trial that the second offense notice was incorrect.
Okay.
It should have been it was the second offense notice listed was for an aggravated domestic violence.
So it should be the 1 year and or $1,000.
That's correct.
Yes.
As a domestic violence second offense. Okay. Okay. So as to sentencing, Mr. Overwater.
I asked the court to sentence my client to time served and close the matter out. He has 162 days credit. He was only found guilty of a misdemeanor. The court heard the testimony. My client's going to be making, if any statement at all, a very limited one, because he does maintain his innocence. He does intend to at least look into a potential appeal. I have sent the appeal rights to him for that. But he also has a hold in Adrian, I believe, on similar charges around for the same complaining witness with a $30,000 bond. My client, as the court's aware, is not only indigent but homeless. He's certainly not going to be able to post that amount of bond. So he's going to be in custody in Adrian for a significant period of time as well. If he's convicted there, then Adrian can put him on probation or do whatever they see fit. But I think under these circumstances, a sentence of credit for time served is appropriate.
Mr. Huizinga, is there anything you'd like to tell me before I impose sentence?
No, I'd just like to say thank you to Ken for everything he's done, and I'm sorry for the situation that's occurred. I feel regretful for it. Not sure what I could have done differently, but I accept my part in this and I apologize.
Okay. Thank you. And that does seem to be sincere. And I do want to state that throughout the trial proceedings, you were very polite with the court, and that is always appreciated. So I am going to sentence you to a term of probation. I think that that would be helpful for you going forward. It does appear that there may be an issue with substances that changes your behavior from, as the victim said, the nice Mr. Huizinga to the not so nice Mr. Huizinga. So I'm going to ask counsel if you believe that maintaining sobriety would be an appropriate goal for his probation.
Yes, Your Honor.
Yes, Your Honor.
Okay, so that will be the goal of your probation. And I'm sentencing you to a term of 1 year of probation and 162 days in the Washtenaw County Jail with credit for the 162 days served. You're not to use or possess alcoholic beverages or non-prescribed controlled substances, and you must comply with any testing and treatment requirements and any assessments of any sort when you're directed to those. You're not to have any contact with the victim, that is Christina Amelia Wanke, either directly or indirectly through another person. You're not to be within 500 feet of her home, school, or any place of employment. And you're to follow all the other standard terms and conditions of probation that your agent will set for you. You're entitled to file an application for leave to appeal from your conviction. You're entitled to file an appeal from your conviction and your sentence. If you can't afford an attorney, one can be appointed for you for purposes of appeal. However, the request for appointment of appellate counsel must be filed within 42 days of today's sentencing. And how will that form be transmitted to Mr. Huizinga?
I've already asked my staff to mail that to him, so it should have been sent to him already today.
Okay, so you need to contact probation within 24 hours from your release from jail. Okay?
Ma'am, so I have,
Yes.
like he said, like Ken said, I have a hold, so how will I be contacting them? And also I'd like to state for the record too, the substance thing, I'm fine with it, but I have 2.5 years sober. I did 7 months in Oakdale Recovery and then did 3 months up in Rise Recovery in Lansing, which is a 3-quarter house. So substance aren't my issue, so obviously it's not going to be a problem. I just want to state that for the record.
Okay, thank you. So maintaining the sobriety should be a piece of cake.
Yes,
So
ma'am.
good. And it's whenever you're released from jail, you need to contact probation. Okay?
Okay, and I don't live in
Looking for
Washtenaw
phones.
County. I don't live on Washtenaw County, so that can be by phone. Is that cool?
They can transfer you to Monroe. You'll need to discuss that with them.
Okay,
Okay?
thank you. I appreciate your time.
Uh-huh.
Your
Good
Honor,
luck to
I apologize. I missed the length of the term of probation.
1 year.
Thank you.
Uh-huh.
Our next two are both in custody. There are only 2 left. So we'll just have to wait.
The next hearing is a non-public hearing. The court will return shortly.
Call the case even though we're waiting.
Numbers 14, 15, and 23, People versus Sean Veeder, 22583 FH, 22587 FH, and 22588 FH.
Michael Doby for the people.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Veeder.
And I know that we are waiting. Oh, here is Mr. Veeder. Good afternoon, sir. The device there is muted. I was going to ask if you could hear me, but somebody's going to need to unmute the device.
Hello.
Hi. Okay, so today is the time and date set for sentencing. Are we ready to proceed, counsel?
Judge, we are not. Could I have a brief bench conference?
Sure.
One moment.
Yeah, what's up? You done with us? decided to get a
Back on the record in People versus Sean Beater.
Okay, and council have entered their appearances. Mr. Overwater.
Thank you, Your Honor. I did have an opportunity to meet with Mr. Veeder this morning, as well as speak with Ms. Stewart from CMH. We are not prepared to proceed to sentencing yet today, although I'm happy to report that Mr. Veeder is improving. But we need a little bit more time for him to stabilize on his medication regimen, as well as I have referred him already to our social work division in the hopes that they can assist him with procuring stable housing upon his release. Which is a big concern for Mr. Beater. In the hope that when we actually have him sentenced, that he'll be released from custody with the best opportunity to succeed. So I'm asking the court to adjourn the sentencing to August 10th. I'm hopeful that we'll be able to resolve the matter then or shortly thereafter.
Mr. Dobie?
I have no objection, Your Honor.
Okay, well, I'm glad to hear that things are going better for you, Mr. Veeder. I do, however, find good cause for the adjournment, and I'm going to set this over to August 10th. That is going to be in front of Judge Slay. So you'll be seeing her for sentencing, and you'll need to sign a sentencing judge waiver. Good luck to you, Mr. Veeder.
Thank you. It's nice working with you. Take care of you.
All right, Your Honor, have a good day.
Thank you. You